Thank you.
Thank you very much. It's a very a warm welcome to all of you, our guests, stakeholders, that is, who assist in disseminating information and helping Zimbabweans access their right to freedom of information and access to it. I thank you for your interest in the work of the Commission and the subject matter at hand. As you will know, the Zimbabwe Human Rights Commission is established by the Constitution of Zimbabwe in Chapter 12 as one of the originally 5 institutions meant to support democracy and constitutionalism. And the Zimbabwe Human Rights Commission doing that from a human rights and an administrative justice perspective. Our mandate is to therefore generally promote democracy and constitutionalism from a bifocal human rights and administrative justice lens. And in doing so, we monitor the human rights situation, we promote human rights. We also have the mandate to investigate where they are of our own volition or through reports, violations of human rights and administrative justice. And also seek to secure appropriate redress, and we are also mandated to and empowered by the Constitution to direct the Commissioner General of the Police to investigate criminal violations of human rights. And we also are also enjoined by the Constitution to advise Parliament on how human rights can be better protected. This is in terms of Section 243 of the Constitution itself. In light of that mandate, the Zimbabwe Human Rights Commission has therefore conducted an analysis of the Constitution Amendment Bill number 3 of 2026. The Commission's assessment examines the bill's provisions against established human rights principles and standards, both domestic, that is our own constitution that creates the Commission, and in terms of which this amendment is seeking to be done, as well as international human rights standards, because as you are aware, Zimbabwe is a member of the Community of Nations and is a member of the United Nations, which is a robust human rights framework, as well as a member of the African Union, which itself is an African Commission on Human and People's Rights. In doing this, the Commission is fulfilling its role, which I have explained already as to what it is that we do and how we do our work. I will therefore proceed to highlight some of the key points of the assessment. Please note that what I'm presenting here is highlights of the analysis of the Commission, of the Commission of the bill. That analysis that is detailed and complete will be available. And we are also going to present that detailed analysis to submit it to Parliament, because the Commission is also entitled, like every Zimbabwean, to also submit its views to Parliament when any legislation is being done. But we do so from the constitutional responsibility that we have to promote human rights and constitutionalism. The first part of the analysis that the Commission conducted pertains to Clause 2 of the bill, which proposes to transfer voter registration functions, compiling the voters' roll, and maintaining registers from the Zimbabwe Electoral Commission, which is one of the Chapter 12 institutions alongside us to protect that are meant to protect democracy and constitutionalism, and transferring those functions to the Registrar General. The Commission notes that that transfer of registration may have the advantage of administrative efficiency, because the Registrar General is the one that registers all people in Zimbabwe. The Registrar General already manages several records such as births, deaths, and national identity documents, and therefore consolidating voter registration under the Registrar General's office could streamline processes and reduce duplication. This centralization may improve data accuracy, as updates to civil records, such as deaths of persons, can be reflected more quickly on the voters' roll. A major concern, however, is the potential compromise of independence of the voter registration function. The Zimbabwe Electoral Commission is designed as an autonomous electoral body, whereas the Registrar General operates under executive control. Shifting responsibilities could therefore undermine impartiality and raise fears of political interference. Of further concern is also that Zimbabwe migrated to a polling station-based voters' roll procedure, meaning that a Zimbabwean can only register to vote for a particular polling station and can only therefore be registered for a particular polling station. Now, it is in terms of the laws that are already present that are sought to be amended. It is the Zimbabwe Electoral Commission that designates what a polling station is. And when it migrated to the the new biometric voters roll that was created, it did so to fulfill that particular process. What stands to question and wonder is how this particular proposed migration of the registration by the Registrar General of voters for a polling station-based voters roll will pan out, because in the bill itself, there is silence on how the mechanics of that will happen, whether the Zimbabwe Electoral Commission will sit with the Registrar General to apportion voters to particular polling stations, whether they will have to work together, or whether the polling station-based voters roll approach would be abandoned. That particular issue is also an issue that that is not appearing from the bill, and that is cause for concern, and that may, if it is not addressed, generate disputes and suspicion and mistrust in the voter registration system, and also particularly the issue of the whole the biometric voters roll equipment and that was being conducted as to will it move to the Registrar General or will it stay with the Zimbabwe Electoral Commission? Those are issues that the Zimbabwe Human Rights Commission notes are potential issues of that need attention, that if they are not addressed, they may cause problems and disputes. The analysis of the Zimbabwe Human Rights Commission proceeds to clause 3, which seeks to change the selection of the president from the electorate, general electorate, to parliament by introducing a parliamentary method of selecting the president, and this, the Zimbabwe Human Rights Commission notes, represents a significant constitutional development in Zimbabwe's governance framework. The Commission notes that the removal of direct electoral participation without enhancing the secrecy of the ballot that voters are presently entitled to stabilizes governance, but risks alienating the electorate and weakening the principle of popular sovereignty. And it brings in the sections of the Constitution that are in the values and principles of the Constitution that pertain to, I believe it's section 3 of the Constitution that sets out the values and principles, founding values and principles of Zimbabwe. That is particularly section 3, subsection 2, that pertains to the principles of good governance, which includes an electoral system. Section 3, subsection 2, paragraph B, which entrenches an electoral system based on 1, universal adult suffrage, and 2, equality of votes, and subsection 3, adequate representation of the electorate. The Commission also notes that removing the electorate from directly voting for the president risks creating a democratic deficit, as citizens lose a direct voice in choosing the head of state, and this may diminish popular sovereignty and could weaken public trust in institutions. But this, of course, can be remedied depending on how that is actually done and conducted. But the Zimbabwe Human Rights Commission points out possible problems that may arise from that. The Commission's analysis also attended to the next amendment, that is the proposed 7-year presidential term. The proposal to extend the presidential term from 5 to 7 years is contemplated by sections 95, 143, and 158, again presents a significant constitutional reform. The extension of the presidential term has been proposed in terms of the bill and its memorandum for the promotion of stability and long-term planning, reduced electoral volatility, and continuity in developmental projects. In addition, less frequent elections may mitigate divisive cycles and foster calmer policy making in terms of the mischief that the bill is seeking to remedy. The Commission, however, knows that longer terms reduce opportunities for citizens to hold leaders accountable and may diminish responsiveness to public concerns. The Constitution, which is rooted in the sovereignty of the people, demands that reforms respect both its letter and spirit. The dual requirement of parliamentary amendment and referendum is therefore crucial to ensure legitimacy and prevent perceptions of unilateral executive consolidation. Please allow me to also refer to an issue that also I had omitted in the earlier issue around the parliamentary selection of the president. The Commission notes that it is encouraging that the Zimbabwe Electoral Commission is envisaged to play a role in that election in Parliament. That the bill proposes that the Zimbabwe Electoral Commission will conduct the election of the president in Parliament, which is recommended and which the Commission finds a positive step. But the Commission also notes that there are two possible administrators of the election. It is the Zimbabwe Electoral Commission, or I quote, a designated judge. The Commission notes that the bill does not explain two things. That is, one, either what criteria will be used to determine whether it is the Zimbabwe Electoral Commission or whether it is a designated judge that will conduct that election. And secondly, the bill also, we note with concern, omits also to indicate the criteria that would be utilized in designating the judge who would be able to conduct the poll in Parliament of the president, of the members of Parliament. And that is an issue that the Zimbabwe Human Rights Commission notes is in need of attention, because democratic safeguards and transparency are required in order for that process to be adjudged as of integrity and to continue holding the public trust. Ladies and gentlemen, the Zimbabwe Human Rights Commission proceeded to analyze the next proposal in the bill, that is that of amending, changing the way that the Senate is configured. And this amendment proposes to allow the president to appoint 10 senators, which would raise the total number of senators to 90. Through this provision, the president will appoint individuals with specialized knowledge, which will see the Senate benefit from enhanced technical capacity. The Commission notes that this expertise that is envisaged to be brought in by the 10 senators to be appointed by the presidency will improve legislative scrutiny, policy development, and oversight of the executive. However, the Commission is concerned about the gender parity implications of such an appointment when it is not accompanied by any rider in terms of Section 17 of the Constitution that provides that the state shall take all measures, legislative and otherwise, to ensure that there are at least 50% of women represented in appointed and elected position. Without such a rider, this may very well undermine the women's rights in the Constitution and the principle of equality, because, as you know, our Senate is the only house of Parliament that has that is closest to gender parity. The 60 senators that are elected on a zebra list with a woman on top, and then a man and a woman and a man. And so of the 60 senators, it is guaranteed that there is the gender parity that is required by the Constitution. And then there are 2 representatives of people with disability, one who is a woman and one who is a man, and gender equality is clearly cannot be escaped there. But then there are the 18 traditional leaders who are the component in the Senate that then prevents there from being gender equality. So if this amendment passes to add 10 seats without the corollary rider that there has to be, that the 50% of them have to be women, Zimbabwe will further decline in its approximation of gender equality. Because if you notice that in the National Assembly, the numbers of women who are members of that assembly are continuing to decline, and those are human rights issues that the Commission is concerned about. The Commission, ladies and gentlemen, proceeded to also examine and analyze the clause that I have mentioned earlier that proposes to hive off the delimitation function from the Zimbabwe Electoral Commission by creating a specialized body, and the amendment seeks to, the Commission notes that the amendment seeks to promote good governance, institutional integrity, and greater confidence in the fairness of electoral processes. The Zimbabwe Human Rights Commission notes that electoral boundary drawing is a highly technical and politically sensitive exercise requiring impartiality, demographic expertise, and transparency. While the establishment of the Zimbabwe Electoral Delimitation Commission has the potential to enhance transparency, technical competence, and institutional integrity in electoral boundary management, strong safeguards against politicization and duplication are necessary, in the opinion of the Zimbabwe Human Rights Commission. The Commission also notes that while these competences are important, the Zimbabwe, there could be a debate as to whether those competencies should be at a Commission policy level or should be included in the technical, in the people who actually work in a commission, the technical people, or whether the Zimbabwe Electoral Commission cannot also even have commissioners who have cartographic experience or demographic experience among them, and then strengthen the secretariat that way. Those are aspects of the analysis that are food for thought for the drafters from the Commission. The Commission notes that the success of the proposed Commission will depend on the robustness of its independence and the clarity of its mandate. The Zimbabwe Human Rights Commission proceeds to also analyze the provision pertaining to the expansion of the mandate of, that is the jurisdiction of the Constitutional Court, to add to it jurisdiction of matters of public importance in addition to constitutional disputes that it already has. The Commission notes that the clause providing for the Constitutional Court to hear any matter on a point of law of public importance marks a significant expansion of its jurisdiction, thus enhancing access to justice, which the Commission commends. While the amendment enhances access to justice and strengthens the court's role as a guardian of the rule of law, it also raises concerns about efficiency, impartiality, and institutional balance. The Commission is of the respectful view that the reform should be supported by clear procedural safeguards to regulate what constitutes matters of public importance, ensuring that the court's expanded jurisdiction does not compromise its core constitutional mandate. The balance is essential to preserve both judicial integrity and the effective functioning of Zimbabwe's legal system. The Zimbabwe Human Rights Commission proceeded to also analyze with its human rights and administrative justice lens the provision pertaining to changing the way that judicial appointments, that is judges of the courts, are appointed. The Commission notes that a new provision for the appointment of judges after consultation with the Judicial Service Commission represents a significant recalibration of judicial appointments. The proposed amendment reduces the Judicial Service Commission's binding influence and increases presidential discretion. The Commission notes that the system of public interview was clearly designed to enhance transparency, democratic participation, and public confidence in the judiciary by ensuring that appointments were not solely at the discretion of the executive. I will just remark as a lawyer that the system of appointing judges in the open way would also allow lawyers that whose names we might not know, but who qualify to be judges, who have no names, to also put their hat in the ring by nominating themselves or by being nominated by others from across the country, provided that they meet the mandatory threshold for judges. All those lawyers who would qualify would be able to also be in the ring without being known or by any particular people in high office. That is what this system has been like. So, however, the proposed amendment would shorten the appointment process, avoiding delays associated with lengthy public interviews and procedural requirements. It may also allow the president to consider broader factors such as diversity, regional balance, or specialized expertise, while still benefiting from the advisory input of the Judicial Service Commission. The Commission, however, notes that such an amendment would simultaneously risk eroding the safeguards of transparency, merit, equal accessibility, and independence that underpin constitutional governance. For the reform to achieve its intended effect without compromising judicial integrity, the Zimbabwe Human Rights Commission recommends strong procedural safeguards to accompany presidential discretion, such as clear criteria for appointments, published reasons for selections, and continued oversight by the Judicial Service Commission, and still an avenue for those Zimbabweans who meet the criteria, who are not, who would not ordinarily be seen or be able to access the process, to be able to also access the process and to become judges from anywhere. The Commission then turns its attention to the clause pertaining to traditional leaders and parties and politics, which is the clause that proposes to repeal Section 281, subsection 2 of the Constitution. Ladies and gentlemen, you will note that Section 281, subsection 2 of the Constitution provides presently that traditional leaders may not be members or office bearers of a political party. They may not act in a partisan manner. They may not further or hinder the political interests of any party, and they may not violate the human rights of any particular person. That is what that provision provides in the Constitution, and the amendment proposes to repeal this particular section. And in the memorandum of the bill, the mischief that is explained to be addressed by the amendment to remove the bill is so that the human rights, the political rights of traditional leaders are not violated by them being prohibited by the Constitution from acting as political party functionaries. The Commission notes that if this clause is passed, it would effectively allow traditional leaders to engage in unlimited political activity with their own code of conduct, and which is not presently in existence, instead of being regulated by an act of parliament. However, what stands also to reason from the drafters is that while the amendment proposes to repeal subsection 2, indicating that an act of parliament must provide for that, what is interesting is that section 282 of the Constitution in subsection 4 already provides that an act of parliament must regulate the conduct of traditional leaders. And so it is interesting that there doesn't appear to be anything really new that is being brought in, but the fact of the matter is that the Act of Parliament regulating the conduct doesn't seem to quite be in place, which is what has been needed. The Commission notes that traditional leaders hold authority rooted in custom and community respect, and that their involvement in partisan politics risks compromising neutrality and social cohesion. Chiefs are expected to serve all members of their communities impartially, but political alignment could alienate sections of their community constituencies, deepen divisions, and undermine their legitimacy as custodians of tradition. Historically, the politicization of traditional leadership, the Zimbabwe Human Rights Commission notes, has been criticized for entrenching ruling party dominance in rural areas, raising concerns about fairness in elections and the independence of institutions. Transferring regulation to an act of parliament also risks weakening constitutional safeguards, such as parliamentary majorities could craft codes of conduct that favor political expediency rather than impartiality. The Zimbabwe Human Rights Commission, as ladies and gentlemen may know, conducts, as I have indicated below, in one of its functions, we conduct investigations into violations of human rights. And the Zimbabwe Human Rights Commission has, over the years, received and continues to receive complaints from the Zimbabwean public about traditional leaders that have acted in a manner that is biased and disfavors and undermines the rights of other people. And the Commission has made recommendations continuously, because the Commission is an evidence-based institution. We actually find out what it is that has gone on, and the Commission has recommendations it has made to the relevant ministers pertaining to the need for traditional leaders to adhere to these constitutional principles of being non-partisan, so that the institution of traditional leadership continues to be respected in terms of our traditions and serves all people. And the Commission has also recommended that the Integrity and Ethics Committee that is required to be established by the Constitution, that has not yet been established, is established. And so I will proceed to indicate that for the amendment, and you are welcome to peruse some of the reports that they should be on our website, the ones that we have investigated pertaining to traditional leaders and the problem of partisan politics. So therefore, for the amendment to balance rights with responsibility, any act of parliament that regulates traditional leadership must include strong safeguards to preserve neutrality, protect community cohesion, and prevent the abuse of traditional authority for partisan ends. The Commission also notes that while the amendment seeks to do this in order to guarantee the rights of traditional leaders, their political rights, so that they may participate in politics, the Commission notes that traditional leaders do participate in politics by voting, like everyone else, and that is participation in politics, and that traditional leaders also participate in Parliament through the National Council of Chiefs, that they elect leaders, in which National Council of Chiefs already has representatives that already sit in Parliament. So the Commission notes that the traditional leaders already participate in Parliament, but that this provision of the Constitution that is sought to be removed only limits their partisan nature, but their partisan politics, that they must not participate in partisan politics. And the Commission notes also that one of the provisions that seeks to be removed is that of Section 281, subsection 2, paragraph D, that reads, and I quote, "Traditional leaders must not violate the fundamental rights and freedoms of any persons." So, ladies and gentlemen, the Zimbabwe Human Rights Commission will naturally be concerned about repealing and removing this requirement that traditional leaders be bound by observing the fundamental rights and freedoms of any person. The Commission notes that such as removing the clear constitutional requirement of traditional leaders to be prohibited from violating people's rights would not be very is of concern and should be reconsidered. The Commission, as I have indicated, knows that there is a need to establish an Ethics and Integrity Committee as provided in Section 287 of the Constitution to develop and enforce integrity on the conduct of chiefs and to ensure that mechanisms exist to prevent traditional leaders from coercing communities into political alignment. Ladies and gentlemen, the Commission proceeds to analyze Clause 4 of the bill that proposes to repeal Part 4 of Chapter 12 of the Constitution, which establishes the Zimbabwe Gender Commission and transfers its functions to the Zimbabwe Human Rights Commission. And the Commission knows that this also represents a structural reorganization of Zimbabwe's human rights institutions in Chapter 12. The Commission notes that the rationale of the proposal is that the Zimbabwe Human Rights Commission already has a broad mandate to protect all human rights, including gender equality and women's rights. And therefore, consolidating functions under one body could streamline oversight and reduce institutional overlap. Ladies and gentlemen, the Commission knows that this reform seeks to enhance efficiency and coherence in human rights protection by consolidating gender equality and women's rights within the Zimbabwe Human Rights Commission, avoiding duplication of mandates. The Zimbabwe Human Rights Commission, however, notes that the repeal of the Zimbabwe Gender Commission risks weakening the visibility and prioritization of gender issues, particularly in a situation that where I've indicated earlier that in terms of there's concern regarding the continually decreasing numbers of women who are directly elected to parliament. The Zimbabwe Human Rights Commission notes that a dedicated gender commission ensures that gender equality receives focused attention, specialized expertise, and targeted advocacy. Transferring these functions to the Zimbabwe Human Rights Commission may result in gender equality concerns being overshadowed by broader human rights agendas, particularly in contexts where resources are limited and competing priorities exist. Ladies and gentlemen, I wish to conclude by indicating that in the very respectful view of the Zimbabwe Human Rights Commission, the Constitution is antecedent to government and people-oriented, as reflected to government that is people-oriented, as reflected by its preamble of the Constitution. And therefore, any reform must preserve the sovereignty of citizens and uphold the rule of law. Ultimately, the legitimacy of these amendments depends on robust safeguards, transparent processes, and genuine public participation to ensure that constitutional changes strengthen democracy rather than erode it. I thank you.
Thank you very much, Chairperson. And we will proceed straight away to any questions that Okay, just one moment, Chairperson will clarify one more point.
Ladies and gentlemen, in the summary, I had overlooked another aspect of the analysis of the Zimbabwe Human Rights Commission of the bill, and that is an aspect pertaining to the amendment of Section 212 of the Constitution of Zimbabwe, pertaining to the Defense Forces of Zimbabwe, which proposes to repeal the clause, or that one of the functions of the Zimbabwe Defense Forces is to uphold the Constitution and replace it with, substitute it with in accordance with the Constitution, which appears as subtle wording but carries important legal and institutional frameworks. The Commission finds positive elements in this particular amendment because it clarifies the Defense Forces' mandate by aligning its functions directly with constitutional provisions. And the term in accordance with the Constitution emphasizes compliance with constitutional rules rather than a broad and potentially ambiguous to uphold the Constitution. And this could reduce interpretive uncertainty, and is particularly commendable because it enforces the constitutional principle that is in that of ensuring that that military authority is subject to civilian control, and that military operations are strictly tethered to constitutional authority, particularly the checks and balances in section 213 and 214 of the Constitution. This includes decisions such as, in practice, deployment decisions remain under presidential direction and parliamentary approval. And such precision of definition would strengthen the institutional integrity and would help the Zimbabwe Defense Forces from assuming expansive and self-defined roles in constitutional enforcement. But it looks like constitutional scholars will also debate that there may be a downside, which would be to which would be to remove maybe the defense forces and dilute their responsibility to resist unconstitutional orders. However, this is also already balanced by the fact that Section 2 of the Constitution already provides that it is the supreme law of the land, and if the defense forces are meant to act in accordance with the Constitution, nothing much may be lost by removing the words upholding the Constitution and putting in place of them in accordance with the Constitution, because that is also in line with the principles of the Constitution. I thank you. That is what I had omitted.
Okay, thank you once again, Chair. So the Zimbabwe Human Rights Commission also monitored the Parliament of Zimbabwe public hearings on Constitutional Amendment Bill number 3. And therefore, the chairperson will also speak to that in terms of the highlights of the Commission's observations during the monitoring. Then after those highlights, we will then open up for questions for both the first analysis that she presented and also the one that she's now delivering. Thank you, Chair.
Thank you, Mr. Mkuchiri. I will not regale you again with the functions of the Commission, because I'm sure we are hopefully more familiar with them, that we are an institution that is established by Chapter 12 of the Constitution to support democracy and constitutionalism through the lens of human rights and administrative justice, and that in terms of Section 243, subsection 1, paragraph C of the Constitution, we have a duty to promote and protect human rights and fundamental freedoms, and therefore to monitor the state's compliance with constitutional and international human rights standards, as well as make people more aware of them. And in terms of Section 243 of the same Constitution, we monitor, we have a duty to monitor the human rights situation in the country with the aim of promoting human rights. Therefore, in line with this mandate, the Commission, from 30 March to 4 April 2026, deployed its teams to monitor the human rights situation during the Parliament of Zimbabwe public hearings on Constitution Amendment Bill number 3. I must at this point say that the monitoring function of the Commission is very broad. We also monitor elections, we monitor natural disasters, we also monitor places of detention where people are held, children's homes, elderly people's homes, hospitals and prisons and police cells, and everywhere where people are. So we generally monitor because of this mandate. And in this particular case, we therefore monitor the process of amending the Constitution, which has been proposed officially. The monitoring exercise was conducted to assess the extent to which the consultation process complied with the constitutional principles and human rights standards on public participation, inclusivity, equality, access to information, freedom of expression, and non-discrimination. The Zimbabwe Human Rights Commission notes that the Parliament of Zimbabwe conducted public hearings in all provinces of Zimbabwe for the purpose of allowing the public to participate in Constitutional Amendment Bill number 3 of 2026, and we commend them for going to all the provinces because they are required to do so. Public hearings on constitutional amendments are founded on the principles of transparency, accountability, and participatory democracy. The Zimbabwe Human Rights Commission noted that overall attendance at the observed consultations was high and included a broad cross-section of the population and vulnerable groups, women, youth, older persons, and persons with disabilities. Venues were at major district centers or public places with reasonable accommodation and accessibility for persons with disability and elderly participants. The public hearing venues, dates, and meeting days were publicized in advance, and the Parliament of Zimbabwe used various media platforms to inform the public, making it easy for potential participants to locate the places where the hearings were going to be conducted. The Commission noted that the public hearing meetings had facilities to receive written submissions, and participants were also reminded and encouraged to make email submissions to the Parliament of Zimbabwe. Across the venues that were monitored by the Zimbabwe Human Rights Commission, it saw that most of the submissions that were aired in the hearings were in support of Constitution Amendment Bill number 3. The most supported proposals included the extension of presidential and parliamentary terms, election of the president by members of parliament, transfer of the voters' roll from the Zimbabwe Electoral Commission to the Civil Registry, appointment of additional senators by the president, merging the Zimbabwe Gender Commission into the Zimbabwe Human Rights Commission, and allowing traditional leaders to participate in party politics. However, of concern to the Zimbabwe Human Rights Commission were the following issues. The Commission found most of the venues to be small relative to the turnout, leading to large numbers of potential participants failing to enter the halls to follow or contribute to proceedings. The Commission also found that while those in support of constitutional amendment were able to give their views, the Commission noted the harassment and intimidation of dissenting voices. Individuals and groups opposed to Constitutional Amendment Bill number 3 were denied audience. Thirdly, the Commission observed instances where participants with divergent views to the proposed amendments were threatened, silenced, denied opportunities to contribute, and in some instances, physically attacked. The Commission noted that there was a strong pattern of controlled participation across provinces. Some entrances to venues were often controlled by young people, with vetting at entry points and supervised sign-in registers with restricted access. For example, in Mashonaland West, there were men who were observed to be holding whips who were involved in vetting participants in Mondorongezi. Such conduct, the Commission notes, violates the rights enshrined in the Constitution, including the right to freedom of expression guaranteed in Section 61, the right to freedom of conscience guaranteed by Section 60, the right to human dignity in Section 51, the right to personal security enshrined by Section 52, and the right to equality and non-discrimination guaranteed by Section 56 of the Constitution. The Zimbabwe Human Rights Commission reiterates that the constitutional amendment process must align with obligations under international, regional, and regional human rights law, including the United Nations International Covenant on Civil and Political Rights, which guarantees participation in public affairs, freedom of expression, and equality before the law, as well as the African Union's own Charter of Democracy and Good Governance. The Zimbabwe Human Rights Commission reiterates its calls for all stakeholders in the consideration of Constitutional Amendment Bill number 3 to exercise tolerance for views that they do not share, to respect those divergent views, and to uphold the values enshrined in the Constitution. The Zimbabwe Human Rights Commission also noted that in contradistinction to the intimidation that we have noted, it also noted that there is media publicization of the process and media campaigns about the bill, which with adverts and jingles that are appearing in the media, state media mainly, at very how can I call it, regular intervals that are in support of the bill. The Zimbabwe Human Rights Commission notes, in contrast, that there are no such jingles or advertisements that are being aired in the state media, and yet there are, from its observations, there are Zimbabweans who have views that are different from the ones that are supporting the bill. And this raises questions in light also of the intimidation that has been seen as to whether those who oppose the bill are also being given an opportunity to freely express them. And the Zimbabwe Human Rights Commission has in previous statements underscored the rights in Section 67 of the Constitution that every Zimbabwean has a right to support or oppose any political view. And has in particular said that those who are proposing amendments to the Constitution have a democratic and constitutionally entrenched right to propose these amendments. And that equally, those who oppose the amendments, who do not share those views, have an equal right to oppose those views because it is their democratic right. And that Zimbabweans are better off, and we can only achieve our objectives when we each respect each other's rights. And I will just end that by saying that if we are a country that has abolished the death penalty, which is an extremely difficult thing to do, so surely respecting each other's different views and allowing everyone to have their say, and then to proceed, if the amendment is to be passed, that it is passed in a manner that is in terms of the Constitution by the necessary voting. If we can, if Zimbabwe can abolish the death penalty, surely Zimbabweans can and should engage in political disputation that is peaceful and should not be intimidated or angered by the views of people, views that are different from theirs, because that is what a democracy is and that is what progress is. And the Commission's view is that the process of amending a constitution must be extremely, if there is such a word, constitutional. It must heed and reflect the principles in the Constitution of tolerance so that Zimbabweans benefit from the best ideas and from the best views, and they listen to each other, and they actually listen to each other speaking and come up with the best ideas. The Commission therefore ends by indicating that calling on all stakeholders again to exercise tolerance, respect of divergent views, and again uphold those principles of democracy and freedom of expression in the Constitution. We end by saying that the state has the duty to ensure the full enjoyment of human rights of individuals despite the views that they hold. I thank you.